Thank you to LHPH for having me back. Last year, I kind of felt like my presentation had a purpose and it was exciting. It's something I'm really passionate about. It's teaching how to identify risk, how to protect your business. Just like I thought Mark's session, which is a really hard act to follow, I thought Mark's session very aspirational, very motivational. This year's session, it kind of fits for this year. This year's kind of been a tough year. And I've been talking about the CARS Rule a lot. I've been writing about the CARS Rule a lot. For those of you that see my stuff in the various industry publications, I've practically had to write about nothing else this year because this is looming on the horizon, and it's really frustrating because we don't exactly know what's going to happen next. So that being said, I am a Texas lawyer. My company, Ignite, is not a law firm. We try to synthesize law and regulation and compliance risk and break it down so that y'all are able to digest it all and run your business in a protected, compliant fashion. That's basically what we do. None of this is legal advice. This is more conversational in nature. So, things that are keeping me up at night. CARS Rule has been keeping me up at night for over a year now. We're going to touch upon some other things too, but this is the big one. And it's really frustrating. I probably get at least 1 or 2 calls a week from somebody. Hey, I saw your article. I saw you speak at a conference. What should I be doing with the CARS Rule? And quite honestly, I'm not sure what to tell them. You know, where we are is that the FTC published the rule. They said it was going to take effect the end of July. Almost as soon as they published it, NADA and the Texas Dealers Association filed suit against the FTC. It's important to understand that the suit isn't about what the rule contains itself. The suit is about, did the FTC follow its own rules in promulgating it? And that case is going to be oral argument next Wednesday, as a matter of fact, the 9th. Don't know how long it's going to take the court to rule on that. You know, my personal opinion, and I should say, I try to keep politics out of anything that I'm saying. I'm just trying to give you the facts. I personally believe that the FTC has some problems in their case because I don't think that they developed this the way they needed to and did the work they needed to. But that's my own personal opinion. I think this is a hard case for the plaintiffs to win. I think that the FTC definitely has some things in their favor. It's going to be hard to get the Court of Appeals to rule in their favor and against the FTC. So, you know, while we're waiting for this decision on that, I don't expect that decision to be given in a week or two. It may take a month or two. We've got the election. And, you know, plain and simple, if Harris wins, then this thing, unless the courts knock it out, this thing's going into effect. If Trump wins, it'll be mothballed in some form or fashion. That doesn't really matter what happens in the court at that point because I think that's part of what he's saying about too much regulation. So there's a lot of ifs. When the FTC agreed to hit the pause button on this, that they said, we don't think this is going to be a very long pause, it may only be a few months. Kind of said that, I scratched my head because I've done enough litigation to know nothing at that level happens quickly. So, here we are in October, they're just getting to oral argument. Again, don't know how long that will take. So there's a lot of questions. So I started practicing law in 1989. I got into this business shortly thereafter. This is the biggest single change that I will have seen in my career that impacts your business, if it goes into effect. This is very big. The only thing I could compare it to, and it was before my time, is when truth in lending law went into effect. This changes advertising, this changes the way you sell, this changes the way you market, this changes a lot of things if it goes into effect. I think that it is going to make it incumbent on everybody to take training a lot more seriously, to record keep a lot more seriously. There's a lot of things going on with this rule. And it's important to note, in the FTC's mind, they don't think they created anything new. They think they basically took a lot of existing concepts and put them all together and federalized it. But they've said time and time again, they don't think this is new. They're already going after dealers. They went after 2 new car operations in the last month. And some of the very language from the CARS rule is in those cases. So they're already moving on this stuff. And quite frankly, I think that they went on this PR campaign and they tried to say, good dealers are already doing all this. And dealers should be really happy about this because this is going to even the playing field. And this is going to make it easier for good dealers to deal with the bad dealers that are doing all these deceptive, tricky things. And you know, from my perspective, that is so inaccurate. First, even if you're a really good dealer doing everything the right way, you're not doing all this. That there's a lot more to unpack. So I think that's a little misleading. And you know, the whole thing about good dealers and bad dealers, and I don't know, I found that all to be very self-serving. I don't necessarily think that it was accurate, and then I was really worried. I actually wrote about this because I'm on Facebook, I'm on other social media, and I'm seeing a lot of dealers parroting that stuff. Oh, I'm a good dealer, so I don't have to worry about this. And I'm here to tell you, yes, you do have to worry about it, even if you are a good dealer. My clients, you know, if you're working with me, if you're working with Ignite, you're really trying to do things the right way, and those folks are still going to have to make changes, and those folks still are going to have a process to go through because there's a lot here. So what are we talking about? High level, that there was 4 foundational pieces of the CARS rule, really a 5th, the record-keeping requirement, which we'll get to. It talks about prohibiting misrepresentations, which if any of you are familiar with your state deceptive acts and practices statute, they usually come with like a list of things that you can't do. Point 1 is kind of like that. Point 2 is this offering price concept. To me, this is the big one. This is the one that I think a lot of people are going to struggle with, and I am particularly concerned about some of y'all that are doing leasing, because I see a pretty high propensity in some of the websites and advertising I see some problems that are going to be brought to attention with the offering price discussion. Number 3, makes it illegal for dealers to charge consumers for add-ons that don't provide a benefit. I really don't know why they had to put this in there. I mean, I think that's already illegal. It's already set forth in a lot of different rules. You know, I've got some opinions about that we'll get to. This express informed consent concept that Ace just mentioned, this is a big part of the rule. This is probably the number 1 reason why I'm really hoping this thing never gets effective. Because quite frankly, I don't want to spend the next 10 years of my career arguing about what express informed consent is. You know, typical government, that they tell you what it's not, but they don't really tell you what it is. And then lastly, not a foundational piece that they've highlighted, but I think the record-keeping requirements are a big deal. I think it's going to be a struggle for some folks. I think that there's going to be some changes, so much so that they asked me to speak at Buy Here, Pay Here United on this subject last spring. And I said, okay, great, but I'm going to bring up some technology providers with me because I think so much of this conversation has to do with your third-party service providers. So we'll talk about that a little bit as well. So, who's covered? The folks in this room, you're doing leasing, you're covered, period, end of story. Some lawyers tried to argue, well, it says sales and leasing and servicing, and if I don't do servicing, then I'm not covered. Well, in the FTC's eyes, servicing means you put air in tires, you clean a windshield. So that doesn't get you anything, so you're covered. Uh-oh. Yeah, thank you. Well, we're waiting for that. I'll just start going, talking about, number one, the misrepresentation part. A lot of it doesn't pertain to you guys. I think a lot of that first foundational piece has to do with mostly what new car dealers do and some of those concepts. What I do think it affects you guys a lot is some of the advertising points. And the big one to me, I look at a lot of leasing websites. I talk to a lot of leasing dealers. I look at the advertising. A lot of y'all don't make it clear that you're doing leasing on your website. I was having this conversation with somebody last night. I had a conversation for 5 years running with a client of mine about this very point. About, hey, I don't think your website does a good enough job explaining this. Like, well, yeah, but it's the website, but in our paperwork, we've got great paperwork, we got this, we got that, we got all these disclosures, and we just agreed to disagree. It's his business. And sure enough, he called me one day last year and said, I had a complaint to the state, and they're asking about, do I make it clear on the website about leasing? So we revamped the website, and we put in FAQs, we put in all this information about leasing to make the argument better. Fortunately, the state didn't do anything to him because his written disclosures were so good that he was having customers sign. I'm a big fan of videos. If you have the capability, do like a short 1 or 2 minute video, educate your customers on what leasing is and what to expect next. Talk about your company. I think all that works really well. To me, the whole reason that they went in this direction, remember I said it's a lot like state deceptive acts and practices laws. The whole reason they did this is, you know the saying, don't make a federal case out of this? They made a federal case out of this. All these laws are already on the books. And what's happened for years is if the FTC wants to go after a dealer for some of these behaviors, they have to partner with the state attorney general and enforce the state deceptive acts and practices law. Well, now with this on the books, they don't have to work with the state AGs anymore. They could do this directly because now that there is a federal rule that applies to this stuff. So there's a lot of stuff in those 16. I think the big one, again, for you guys is leasing. You have to communicate that this is a leasing transaction. You have to be honest about what vehicles are available, when they're available. God, if you read all the stuff that the FTC looked at when they talked about this, there were so many horror stories from consumers. And one of the things was, well, they lied to me. They told me they were going to trade in my car, and they never traded it in, and now I have this problem with my credit. That's part of my whole issue with what the FTC did here, that they kind of took the worst stories that you could possibly imagine, and they brought them all together and said, okay, we're going to build a law around that. And, there are some parts to it, again, I think are fair, that there are some parts I think they're a little unfair. I think the biggest problem with the whole rule is, and I don't mean this flippantly, I swear, I don't know that these people ever bought a car before. Because they approach this so linear. And by that I mean, customer walks into a dealership, asks about that car over there, and has one conversation. And we all know it doesn't work that way. I got this much to spend, I got this much down, what could I get for that? Well, tell me about this car, what about that car? Does that one come with the warranty? Well, this one... It's not linear. It is anything but linear. And I keep on getting back to, I think that is a very fundamental flaw when they went about all this. So, next. Dealers have to clearly and conspicuously disclose the offering price. And that basically means what somebody's going to have to pay to leave with the car, other than if it's a state inspection fee or some state mandated fee. So for instance, in Texas, where I'm from, dealers are allowed to charge dock fees, but dock fees are not mandated. So now if you're advertising the price of a vehicle, you'd have to include that dock fee in the offering price. You wouldn't have to include tax, title, license, state inspection, things like that. So it is going to change the way prices are advertised. I had a client from Houston call me a couple of weeks ago. They're ticked off. They have a big competitor, and they feel like the big competitor is undercutting them because the big competitor isn't talking about dock fees and some other fees in their pricing. And they asked me what I thought they should do, and I said, quite frankly, I don't think you should do anything right now because we don't know when this is going to take effect. When it takes effect, they're going to have to stop doing that. It's a big chain. It's not like some little guy that hopes they don't get noticed. It's a big chain that will make that change. Again, for you guys in the room, I think the big takeaway is you have to go back to the concept. What do they have to do to be able to leave with a vehicle? You know, I live in Florida right now. In Florida, there's a big issue because dealers are allowed to add a pre-delivery service charge, and there's no limit. You see folks $200, you see other folks, I'm not kidding, like $2,000. And again, that's something that the FTC got really involved in when they developed this rule. They told those horror stories. You know, I read the whole thing last year over the holidays because I had nothing better to do. It's like 300 pages of just trashing the industry over the worst stories imaginable. One of which was, well, I called and they told me what the price is, and I drove 3 hours, and then it was $3,000 more by the time they added in all these other things. So that's really what they're getting at, that egregious kind of behavior. I think that the really important thing to take away is if add-ons are not required, you have to tell them that. You have to tell them what the price is. The total number of payments for a finance or lease transaction. So I call that trigger terms on steroids. You know, because right now, if you tell somebody that the down payment, you also have to tell them what's the APR, what's the term. You have to give them all this other information. Now what they're saying is, no, you have to tell them the total amount that they're going to have to pay if they make all payments on time, which, you know, head scratcher, when's the last time that happened? But they're going to have to tell them what the total dollar amount looks like. Again, transparency is key, and they really want dealers to be honest about that. Monthly payment comparisons, and I think this is one that's going to cause some problems. It's just a practical matter, just because I know what happens at the stores. You're talking about this car here, you're talking about that car there, and then, well, I really can't go past $450 a month. Okay, well, we could extend the term a little bit. Well, when you extend the term, according to this rule, you're going to have to tell them, well, here's how much you would have paid if it was 36 months, and now here's how much you're going to pay over the life of it if it's 42 months. So it's not just the payment amount changing, it is the total number of payments over the life. Sounds simple enough, but I used to work for a DMS, and I know how hard it is to you know, we're dealing with one number over here, and then we got to go back and get a number over here, and we're expect sales folks to be able to do this in real time. And again, you might be talking about multiple vehicles. I think it's going to be a challenge. And I don't know if it goes into effect, if the FTC gets a good ruling from the court, if Harris wins and it goes into effect, I think they're going to say 6 or months less to put this into effect. And the reason I say that is because they were really clear about how when they took a pause, they said the pause might not be very long. I think they're going to come back and say, well, y'all have known about this for 1.5 years now. You should have been taking steps to do it. So we're not going to give you very much time. And that scares the hell out of me, because I'll tell you right now, except for the big boys of the world, nobody is staffed to take 500 calls from dealers all at the same time, needing to change their advertising, needing to change their setting, needing to add documents. It's a big problem. So I'm very trepidatious about that. Okay, illegal to charge add-ons that don't provide a benefit. I kind of call this the duh. That's already illegal. But again, they felt that they needed to put it in writing. They give you great examples of what you shouldn't be doing. The nitrogen-filled tires that contain no more nitrogen than the air, extended warranties that are duplicate of another warranty. The one that they snuck in there that I think is really difficult is they talk about gap agreements and they mention loan-to-value ratios. And I've talked to a bunch of lawyers about this, and everybody kind of is in agreement that, okay, if this comes to fruition, you're going to have to do some sort of LTV calculations on your deal to make sure that you're not taking a big enough down payment to where the LTV really makes the gap unnecessary. And that scares me because I think that is, again, they didn't give a bright line. They didn't say, okay, the number's 25, 30%. If they did, great, I got no problem with that. Just tell us what it is and we'll shoot for it. But they're leaving it very subjective, and I think this is the type of stuff that plaintiffs' lawyers love to attack. So I think we're going to see some activity here down the road, and that worries me. Dealers must obtain express informed consent. This is this concept, and it's not new. It's been around in various state statutes for a while. But express informed consent, like I said earlier, what worries me about this is I don't want to spend the next decade arguing about what it is. They told us what it isn't. You can't pre-check boxes, you can't do this, none of that's express informed consent, but it would have been nice if they said, you know what, everybody use this form right here. The ironic thing about express informed consent is, NADA has a great menu, and it's been the standard for years. You list all the products that you're selling, you list the price, you have a customer sign it, they say it's voluntary, boom, great. Technically, that wouldn't be sufficient under this. And Ace, you still in here? Because Ace recently visited with the FTC about this issue. And he called me afterwards. We had a great conversation about it. So Ace, why don't you just kind of share what that conversation was like?
Yeah, everybody said I was crazy to go ahead and call them, but after I told them my story about my interaction with the CFPB, they said, okay, go for it. And anything you fear and you face makes you stronger, and that's what I was looking for, to make us stronger. And I met with the FTC. It was supposed to be a 30-minute interaction, and it ended up being an hour and 15 minutes. And it wasn't because we were doing anything, it was because they were asking a lot of questions. We focused right on express informed consent. And like Steve said, we know what it is and what it isn't. It isn't a signature and or a checked initial box. And so we said, we need to understand what that means. If a signature and a checked box isn't express informed consent, we just rewound 1,000 years of contract law. And so we really need to understand what that means. And so when we showed them our avatar going through what we believe is express informed consent process, we hit a nerve with them. And they continued to attack us, and we like, whoa, let's step on the brakes a little bit. We're consumer facing, we're a consumer and a dealer project. And the one thing I'll never forget, Carol Reynolds said, she's the lead attorney for the consumer protection part of the FTC. I said, the dealers really like this, being able to be transparent. She goes, I bet they do. I bet they do like having the recordings done. And I knew we had a problem at that point. But yes, it was great, and it taught me a lot.
I think the big challenge for the industry is going to be the attacks. There's no accident that Reynolds and Reynolds and all the big companies, you notice nobody's published an express informed consent form yet. They're working on it, but nobody's willing to come out there and push it right now. They want to see what happens next. Eventually, we're going to have these forms, and you better believe plaintiffs' lawyers are going to want to push. They're going to want to challenge and see how far they could go. And how far they go, quite frankly, is going to depend who's in the seat, who's calling the shots. One comment I will make, and this is an observation, again, not political. I've noticed that this FTC, this CFPB, they are not afraid to push the envelope and be very aggressive in what they're trying to accomplish. And if they get overturned in the courts a couple of years later, that's okay. Because they got the big headlines and they got 2 years of juice from doing it the way they want to do it. And if it gets overturned, they'll live with it. And that's one of the things that really scares me so much about the climate right now, because there's a lot of that going around, both at the federal and state level. So lastly, the record-keeping requirement. Again, I used to work for DMS. I think this is a bigger deal than a lot of people think it is. You're going to have to keep 24 months worth of records. Well, so what? We already do that. Yeah, you do. But pretty much everybody's got holes in that. For instance, if you let your salespeople use their personal cell phones, that's a hole. If your CRM isn't capturing everything that happens through every point of the deal, that's a hole. Those holes are going to have to be closed. I've talked to some of the technology providers about what they got in mind, that they do have solutions, but it's going to take a while to accomplish all that. And again, if this is supposed to happen in 6 months from when they announced that the pause is lifted, good luck. The other thing is, if you make somebody an offer and you don't sell the car or lease the car, you still have to keep those records. And that's a big change from what we got today. Basically, what the FTC's done with this record-keeping provision is they've said, look, we don't want to audit somebody and hear, oh, we got rid of that. We don't have that anymore. So they've taken away that excuse. That they want to see everything for 24 months. That's going to involve your advertising. That's going to involve training materials, scripts, anything that you're using. If you are, and I have a lot of clients, they like to jump around with their add-on products. You're going to have to keep all that stuff. And they want consumer complaints. If a consumer complains about something, that they want to see that you have a record of that and you're keeping track of that. I ran into this with a client a couple of years ago in, I think it was Rhode Island. And luckily, the client had really good complaint management, because they basically said, we want to see these 15 complaints that you've got over the last several years. And luckily that they had it all in their system, they had it documented. If they were missing one, they would have had a nightmare, but because they had all the information, never heard from the state again. So, what else is keeping me up at night? Well, the FTC, because in addition to all this stuff, and this is a lot, they brought a lot of actions against dealers in the last couple of years. They are seeing discrimination. They are looking for discrimination, I think, even when it doesn't exist. And they are looking specifically in how you're selling products, how you're pricing products, who's getting what deals. Very scary. And again, I think this is something, goes to what I said earlier, they're not afraid to put it out there and they get struck down on appeal later. They're going after dealer principals and employees, that they're going after management. They're making this personal. They are very interested in reviews. And I got to tell you, I did a project last year for a 20 group. I looked at 20 of their websites and saw how they were handling reviews. And there's a big problem with the way a lot of folks do reviews, because you're only putting up your 5-star stuff. And the FTC has said, no, that's deceptive and misleading. If you're going to do reviews, you have to say both the good and bad. You should have dates next to it. You can't just cherry pick. So CFPB is still on its warpath about junk fees. Fortunately for our industry, the CFPB has gotten into so many things. I mean, I don't know if y'all been paying attention to what they've said about student loans and credit card debt and medical debt. They've kind of started chasing some other things, so they haven't been as heavy in our space recently. But the one thing that both them and the FTC seem to be like jockeying for position on is junk fees. They're all over junk fees. So I tell my clients, any fee that you're charging, we got to have a justification ready for it. I mean, like chapter and verse. Let's go to the statute. Let's understand why you could charge it, and just keep that in a drawer. If you get asked, you have it. Understand what you are charging and why you're charging it. Make sure that you have permission. I see this a lot. Well, we've always done it that way. That ain't going to work. You have to have a justification for it. The deficiency balances, those of you that go after garnishments, those of you that take post repossession collection efforts, this has been a big area at both the state and the federal level. CFPB started, and then all the states got on it to where it's now standard in audits. I'm very worried about what the next 4 years are going to bring. In a Harris administration, another 4 years of the CFPB and the FTC going like this, it's going to make it really hard, and you guys are already under a lot of stress. The safeguards rule. Safeguards rule scares the hell out of me because, quite frankly, I speak to a lot of you, even plenty of clients of mine. You're not doing what you need to be doing. You're hoping. You're hoping you don't get nailed. You're hoping you don't have a breach. The CDK breach and now the Mannheim breach is going to redirect a lot of attention towards the industry. We're already seeing it. You have a lot of congressmen wanting to know why people weren't able to buy cars for 10 days. You have a lot of people asking questions. It is very important that you have some controls in place for safeguards. If you don't have a written information security plan, if you don't understand what your duties are to do a risk assessment, if you're not doing any sort of penetration testing, you need to get on the ball. There's a big difference between IT people and cybersecurity people. And you need to be asking your IT people, do you need help here? My experience, a lot of the IT people don't want to admit that they need help. So you need to ask them, what do you know about cybersecurity? Do you need help? Something is better than nothing in this situation. I talk to a lot of folks. I see them at the conferences year after year. Have you done anything yet when it comes to safeguards? Well, that's in our budget for next year. They're just pushing it down and hoping. Do something about safeguards, because if you suffer an incident, pretty much every state now you have to report it. The FTC says if it involves more than 500 records, you have to report it. This is really serious stuff, because if you are found to have not reported it, it's like bet the business type of behavior. Regulators are going to take that very seriously. Lastly, my own clients are keeping me up at night. I know it's tough out there. I know there's capital challenges. I know it's hard getting cars. I know there's all these really tough pressures the past couple of years. And I've heard a lot of that, we're not doing it this year. Let's push our audit back a year. I get it, guys. But unfortunately, you can't tell that to a regulator. I had a client that tried recently. They got examined by the state. The state found some things, and they showed them all these challenges they were having. The state didn't care. You got to be doing something. Worse than the state is the plaintiff's lawyers, because they're going to try to say that you're consciously indifferent, that you were negligent, that they're going to try to build something into punitive damages cases. I'm not saying you have to throw the kitchen sink at this stuff every year, but I think there are some basics that you need to do. We could teach you how to do some internal audit work. We could work with your team. If you don't want us to do it, fine. But let us help your team learn how to do some of this stuff and protect you better, because this stuff isn't going away anytime soon. We have a lot of content out there. We do a tip of the week every week. We do webinars every month. It's all complimentary, no obligation. Just shoot us an email if you want to be on our list. We love talking about this stuff. Many of you in this room know you're not clients, but you can pick up the phone and call me, and we'll have a conversation about what's going on with you. So with that, keep us on schedule. Thanks, everybody.